Hi everyone, Keith Carlson here, Carlson Jai Kumar. Wanted to bring you some more cases that we were watching out of the Ninth Circuit and the California Courts of Appeals in the middle of September. First one up is Keeton v. Tesla. Tesla's back on our review list, this time regarding arbitration provisions, specifically in a discrimination, harassment, and retaliation case in Alameda County. The parties agreed to arbitrate the case, but apparently Tesla didn't file its fees within 30 days as required by CCP 1281.98. So the plaintiff sought to remove the case to Superior Court. The big thing to watch is Tesla's claim that the CCP section actually is preempted by the Federal Arbitration Act. With all the recent cases in California we've been seeing, including those we wrote about in our newsletter on paying fees on time, it'll be interesting to see if the FAA is going to preempt California's strictly enforced 30-day rule, which we've seen come up again and again quite a bit lately. It also feels like generally the normal deference and desire to have cases arbitrated in California is starting to give way to some technical applications of CCP, starting to favor again sending it to Superior Court. We'll keep an eye on that and see what happens. Anoke versus Twitter, next one up, is another Elon Musk in this category. He wins some, he loses some, specifically as to paying arbitration fees. Here, Twitter allegedly didn't pay their arbitration fees within 30 days, just as Tesla had not in the earlier case. Plaintiff invoked the same code, 1281.97 of the California Code of Civil Procedure, and tried to move it back to Superior Court. But in this case, the plaintiffs had mistakenly paid the fees Twitter was supposed to have paid. The arbitrator caught that after deeming them paid, refunded them, and asked Twitter for them, who did pay the second time around within 30 days. And the Superior Court and then the Court of Appeal said that that's timely paid, no harm, no foul, and they're going to let that case stay in arbitration. So he won one, he lost one. Up to Samuelian v. Life Generations. This is an interesting case involving healthcare facilities, California's non-compete law, and arbitration. Basically, Business and Professions Code 16600 generally prohibits non-compete agreements throughout California, and always has. That law, as we wrote about recently in our legislative update, has also been strengthened legislatively, making it even harder to have non-competes enforceable in California. But here, a part owner of a company sold part of his shares, and the company tried to enforce a non-compete agreement. The Court of Appeal ruled that the arbitrator who was handling the matter applied the wrong law in analyzing the non-compete agreement and opened the door to the company that runs skilled nursing facilities and other healthcare facilities to actually be able to apply a restraint of trade, which is something you don't see in California too terribly often. Next up, Dignity Health versus Mounts, another hybrid employment and healthcare case. Dignity Health sued Dr. Mounts for the repayment of money under a Physician Recruitment Agreement. Dr. Mounts counterclaimed, claiming retaliation. There were all sorts of issues in this one: practice competency, peer review, an 805 report, the whole spectrum you can think of in an employment healthcare hybrid case. Ultimately, the doctor resigned and Dignity wanted some of the recruitment monies paid back. When Dr. Mounts counterclaimed, Dignity brought and was initially denied an anti-SLAPP motion. The Court of Appeals reversed the first one. It sent it back to the trial court and ruled that it needed to be reviewed again. There, the trial court ruled Dr. Mounts did not show a probability of prevailing for a number of reasons, one being the litigation privilege under Civil Code Section 47. So here it got back to the trial court, back up to the Court of Appeal for the ruling we got just recently, and the Court of Appeal affirmed the trial court's decision, which had the effect of striking the doctor's cross-complaint and awarding Dignity attorney's fees and costs. Next up, we have D'Augusta versus American Petroleum. This is a Ninth Circuit case involving a complicated theory by motorists claiming the United States, Donald Trump, Russia, and Saudi Arabia had a conspiracy to impact and affect gas prices in California. It's interesting because first, it's bizarre, but also because the Ninth Circuit affirmed a dismissal based on separation of powers, namely the executive branch has sway over, quote, political issues, close quote, and the judiciary should not be interfering in those. I believe enhancing separation of powers doctrine may ultimately, though not through this particular case, impact many administrative law matters throughout California and the country. And that will in turn impact employers and licensees of all types. Licensees, of course, subject to their board's administrative matters all the time. And there are all sorts of administrative agencies, employers of all stripes can be subject to. Also up, Clarke v. Gordon. This was a case where the Court of Appeal overturned a writ of mandate a denial. It had to do with the DMV. And once again, it was under the administrative law umbrella. The court we see reigning in administrative law power is important for many licensees. And this one had to do with the due process rights denied to a driver. But for those of you who read our Supreme Court review newsletter, you'll remember we spent a lot of time on administrative law regarding Chevron deference. So we're going to keep an eye on those issues here. Hope you're having a good week, and we'll provide you with another update in California law soon. Thank you. Bye-bye.